Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is what seeds need to be sown? The role of antitrust in agriculture. So agriculture sits at the center of the U.S. economy. Of course, the U.S. is a world leader in making things grow, pulling them out of the ground. And frankly, agriculture, our own domestic agriculture, is central to food security. But perhaps it is even more central to American culture and who we are. And that places agriculture in a very, very important place in American society. There have been questions recently about the degree of competition in agriculture, and they involve a range of issues. Some not maybe aren't too surprising, like simple price fixing allegedly in certain proteins, but others may surprise you. There are very complicated technology issues and intellectual property issues that play into agriculture competition. Today, we are lucky to have a guest who's going to give us some context, talk about the range of issues that play into competition in agriculture and the role of antitrust. My co-host today is Tammy Zhu. Hi, Tammy.
Hey, John.
Tammy, what are we talking about today?
So we're talking about competition and antitrust issues, starting from the earlier days of agriculture in the U.S. economy and how those evolved and shifted and how we got to today's highly concentrated and consolidated industry. And also from today to going forward, we see the rise of tech platforms and application of big data analytics to the agriculture sector. And we're interested in seeing and asking how that big information exchange and potential will affect competition and antitrust issues going forward in the agriculture sector.
Great. Who's our guest today?
Our guest is Mark Tobey. So Mark is one of the leading authorities on antitrust and competition matters in agriculture. He spent a decade at the U.S. DOJ, where he served as the special counsel for agriculture. There, he handled merger reviews and conduct investigations. Mark was also involved in running a series of workshops across the country about antitrust issues in agriculture. During those, he worked closely with farmers, processors, advocacy groups, and also the U.S. Department of Agriculture. Mark, right now, he currently counsels food and agribusiness clients in private practice at Husch Blackwell. Welcome, Mark.
Thank you, Tammy.
So, Mark, let's jump in. Let's start with the earlier days, the past. Tell us about some of the competition and antitrust issues that you saw in those earlier days, and how those led to the market concentration consolidation that we see in the agricultural industry today.
I'm happy to do that. Thank you for giving me the opportunity to talk about these matters in agriculture. I should just sort of begin by saying that, consistent with what you've said and what John said, the agricultural trusts that were out there, the huge trusts in the 1880s and 1890s were a big spur for the adoption of the antitrust laws originally, the Sherman Act in 1890. To talk about agriculture, I would like to focus on those workshops that we had now 10 years ago in 2010. And I'll give you a little bit of background in the process on me and on agriculture. I came to the Department of Justice where I was planning to work pretty much on state attorney general relations for the division. That had been my background. I was at the Texas Attorney General's office doing antitrust for 21 years before coming to DOJ in 2009. But I wanted to come to DOJ, and in discussions with the new leadership of the Antitrust Division, it was clear that they had in mind a major initiative on agriculture and asked me if I would head it up. So actually, the day before I came to work at DOJ, there was a Federal Register notice with my name as the contact, announcing a series of workshops that the division, along with, or I should really say the Department of Justice, along with the U.S. Department of Agriculture, were planning for 2010. And so I prepared myself as much as I could, but I grew up in suburban Dallas, Texas, a long way from, being a farmer or knowing that much about agriculture. What I knew about it was from my antitrust work, where we work across different industries. And I was generally familiar with it, but not steeped in it. So for me, this was a wonderful opportunity to do a deep dive into agriculture. And it is so important. It really is our food supply. And with population growing and the impacts of climate change, making it more difficult to find cultivatable land, agriculture is extremely important, and the future of agriculture is important to us all. So I was glad that this opportunity presented itself. It was a priority at DOJ, and it's a lot of fun to work on a priority project because we had the direct involvement of the Attorney General, Eric Holder, and the Secretary of Agriculture, Tom Vilsack. We decided early on that we would leave Washington to do these workshops because we wanted to talk directly to people that did agriculture every day. And so we made a few decisions early on to go out from Washington for the 4 of the 5 hearings, and we put together lists of academics, and we plumbed the information that we had about agriculture groups to try to begin to put together panelists. This was a very unusual thing for DOJ. We didn't have any particular problems that we were looking to get information about. We really wanted to hear directly from the people. And the way we set up our panels, it was designed to have farmers and producers and people in agriculture talking directly to policymakers. And we also gave opportunities for people to talk about whatever they wanted to talk about to the policymakers. So it was very powerful.
Yeah, Mark, that's actually, you don't hear about that often, right? Where policymakers go out and so often there are layers of lawyers or lobbyists or advocates between the real people and the policymakers. That must have been quite a educational experience to sort of hear directly from people who are not to be crass, but getting their hands dirty, actually growing stuff.
It was, and I was really pretty inspired by what I saw and what I heard. We heard a lot of people talking about how important these workshops were to the future of agriculture, so important that they drove long distances, that they arranged to have their neighbors milk their cows or tend their flocks or whatever to come to these workshops. And they came and they stayed all day and they really listened and they really participated. at one of our workshops in Fort Collins, Colorado, where we talked about livestock, we had 1,700 people. There were so many people there that we had to have overflow rooms for people to listen to what was going on. So, when we approached this, we didn't know exactly what we would hear. We heard a lot of things from people. We wrote a report, by the way, that's still available on the DOJ website, and I think there's a link available in connection with this podcast that kind of summarizes what we heard. In fact, the entire proceeding was videotaped, and there are transcripts still available on the website. But we weren't really sure what we would hear. We heard a few themes that I think were really kind of came through. One of them, of course, was market concentration in agriculture markets. And, we heard, directly from some farmers that merger policy in this country is broken, and it's been broken for a long time. And, when you talk about how did these markets get concentrated, it was frustrating because a lot of that market concentration happened, 30 years before the workshops. And so we were faced with the fact that, the authority, at least current authority under the antitrust laws, doesn't allow, DOJ or the FTC or anyone to really deconcentrate markets or to do things in a way that we think those markets should be organized. So that was certainly one of the themes we heard.
It's very, very complicated to unring the bell once the demerger is done. As you say, 20, 30 years ago. I mean, how do you? There's nothing left. Whatever was no longer exists. So, well, anyway, that's what are some of the other themes you heard about?
Well, we heard, and I'll say this, we heard a lot of things that sounded like nostalgia. Years ago, I had, I could get cheap seeds. I could save my seeds and, clean my seeds and use them the next year. And we heard that people had many, many markets that they could sell their goods into, and they had less now. And you could say, yeah, well, that's yearning for the old days. But, honestly, I, came to understand that for farmers, this market concentration is real. They produce a product. They need to have that product, marketed, and many of them need to have their products further processed in some way. So the concentration at the processor level was something we heard a lot about as well. And, embedded in all that is the issue of monopsony, the powerful buyers, the consolidation that resulted gave the buyers of the agricultural products a lot more ability to dictate terms and price. And, there was a lot of unhappiness about that, but I wouldn't characterize it as nostalgia. It was based on the real world. And we did hear a lot about seeds. That was a big issue at the time of the hearings. Monsanto and the DuPont with their Pioneer seeds were battling in rural America. We had breakout rooms sponsored by both companies at the Iowa workshop that kicked off the proceedings, and we had a panelist on one of our panels from Monsanto. People really wanted to talk about seeds. This is an area where instead of being able to keep your seeds and clean them and use them, now, and increasingly it's the case that with the advanced genetics that are in seeds, you have to sign an end user license agreement, just to have your seeds. And you have to sign a new one each year, and you cannot, keep and reuse your seeds. So we heard a lot about that.
Yeah. So, Mark, you had mentioned that the workshops were happening around 2010 and shortly afterwards. And then we saw, in terms of the timeline of things, in 2015, 2016, some of the big seed and chemical companies start to buy one another and merge. And my understanding is that you had a role in these. You were reviewing and analyzing these mergers. So, what was something important from what you learned in the workshops that affected how you looked at and reviewed these mergers and think about remedies?
Well, I think what we did learn, what we heard over and over again, was how important vigorous antitrust enforcement is to keeping these markets functioning well for farmers and producers. And so we did a number of things, some of which, really never, kind of became visible publicly. But even though we did not get any, breakthrough ideas for new lawsuits coming from the workshops themselves, we formed a task force with the U.S. Department of Agriculture, ramped up our coordination with the USDA. We started looking at complaints that came in to either DOJ or USDA to see if there's a way to be involved and help move the law forward. Looked at appellate issues. Then when we looked at mergers, I'll get to the big mergers, but when we looked at any sort of agriculture merger, because it was so much out there that DOJ was looking at agriculture, for a while there, it seemed like the level of merger activity in agriculture was down, compared to many other industries. And the ones that came through were not that big, but we looked very closely at the ones that came through, at the monopsony issues. And, our knowledge of the industry helped us, spot the issues that really made a difference. So we brought a couple of different lawsuits in that time frame. One was involving the acquisition of a small poultry processor in northern Virginia and West Virginia, called George's. And there was not a lot of commerce involved in that. But the reason we brought the lawsuit was this would have given Tyson additional power to degrade the terms that are used in signing up poultry growers for working for Tyson. And so we wanted to sort of put that out there. And we wound up resolving that case rather quickly after we filed it. But that's an example. We also did one involving Tyson again and its purchase of Hillshire, which was a pork producer, a pork processor. This time we focused on sows, that's female hogs that are sold for slaughter at the end of their productive breeding lives. And, it was not a huge amount of commerce, but the profit margins for farms are very slim in many cases, and just being able to sell your sows was an important piece of the profit margin for farmers. So we actually found there was an overlap between Tyson and Hillshire in selling or purchasing sows. So this was a monopsony case, and we required Tyson to divest its sow purchasing operation. So those were a couple of those small ones that happened as a result of the workshops. A few years later, we then began to see very large mergers. What you were asking about, kind of back to back, we saw Dow and DuPont merge, and we saw Bayer and Monsanto merge. And, those were major consolidations that happened, some of them so significant, the overlap so significant that, they required very long investigations and very intricate consent judgments.
And some of those bigger mergers, I think, again, lead to very, very complex issues, right, Mark?
Very complex issues. We had a large team. I worked on both mergers, more so on the Bayer Monsanto merger, but trying to just figure out how to deal with these overlaps. It would have been very difficult to challenge a merger with, say, in excess of 20, overlap product markets. We tried to think of a way to remedy, and so we actually found a good company called BASF that was really only in the chemical side of the business and had never sold seeds. But we required the merging companies to divest pretty much all of the seed operations of one of the companies. And they took it over, but we had to make sure they had the resources and the personnel and the seed libraries and all of the things that go into competing in the seed markets. So that that took a lot of time and energy.
Mark, in analyzing a big seed merger, like the Bayer Monsanto merger, what was the most complicated issue there? Like for antitrust lawyers, what would you say is the hardest part? Is it like defining the relevant market? Is it identifying the overlaps? Is it the theories of antitrust? Is it figuring out the remedy and maybe the who is the inappropriate divestiture entity? In your experience, what was that? What was something that was really difficult?
Probably all of the ones that you mentioned, but I think one of the difficult ones was to figure out what products that these companies had in development that would become important in the future, and those were at the margin. That was where a lot of the controversy and long discussions were. It was also the case that because of the concentration of these markets, it was hard to find a buyer. It was hard to find anybody who had the resources to manage a portfolio of the size that we felt needed to be divested. We actually found the company. We worked very hard on the remedy. This was one of the first cases that I had seen where we had a managing or monitoring trustee that was going to help to make sure that the acquiring company, had whatever it needed to be able to compete. We put provisions in the consent judgment that they could basically come back. The divestee could come back and ask for additional resources if they found they needed them in order to replace the lost competition from the merger. All those were pretty challenging issues.
Yeah. Should we shift to Mark? Do you want to talk about some of the issues that you're seeing today in antitrust issues in agriculture?
And agriculture continues to be very vibrant, and I will say that despite the fact that there are many issues for farmers and producers today, they have continued to work. I mean, this current trend, toward fewer and fewer markets available. The farmers have worked on their own and sometimes through their agriculture cooperatives to develop export markets, and exports have become increasingly important. And this was one of the aspects of what we saw in the early days of COVID, when the markets, the domestic markets, were not getting the amount of product that people needed, in part because the way that the supply chains had been set up over time was a lot of it was going to export. And there's really nothing nefarious about that. This was a way that farmers, settled on to try to find new markets for their products. I'll say from the processor point of view, also, what's been happening with COVID presents some real challenges. The president signed the executive order essentially requiring the meat processors to remain open, and yet they had real significant health concerns on behalf of their workers. We saw lots of processing plants being, virus hotspots. And so you combine that with the other thing that's going on these days with agriculture is a whole series of private class action cases involving almost every one of these proteins, chicken, beef, poultry, pork, and even salmon, where these markets are being scrutinized very closely, both by DOJ and the government and by the private class action lawyers. So it presented a real dilemma. If you if you slow production, you face a potential accusation that you're trying to raise prices by limiting output. And so it's a kind of a rock and a hard place situation for a number of these processors.
Mark, it's interesting. It's interesting to think about where we're going next in agriculture, because I think a lot of what you may see is are technology issues that drive a lot of the next level competition concerns. Things like, we talked about seeds, but things like intellectual property associated with seeds, even things like software copyrights associated with tractors that limit farmers' ability to repair the tractors. So the thing that I find fascinating, as I said, you're absolutely right. There's huge scrutiny into the protein markets, although in some ways those are sort of simple antitrust cases that even someone like me can understand. The next level seems like it's going to be even more complex. I was wondering what your thoughts were on that.
Right. I mean, if you, first of all, agriculture law generally, outside of just antitrust, is this amazingly complex and, lots of different issues and different types of legal disciplines that are involved in agriculture law. And and some of these, if you want to get an idea of that, the American Agricultural Law Association, has an annual symposium. You look on that list of issues, you see just, a vast array of things, such as the use of blockchain technology for traceability of agricultural products, which is very important now with foodborne illnesses, and a regulatory scheme that's growing up around bioengineered products. But with regard to, as Tammy mentioned at the beginning, kind of the big data issues, you're really starting to see that too, and the issue of every one of these machines now that is used in the field generates data, and it's all collected in some way, either by the farmer or by some of these big companies that we mentioned. Dow DuPont and Bayer Monsanto have platforms that really collect and manipulate this data and can get to a point where they could come down to a very granular, prescription for the farmer about where to plant and when to plant and what to plant and how much to water and when there are problems, disease problems, and when to harvest. And this is important stuff, but it's going to create, I think, quite a few antitrust issues eventually, which are likely to bubble up. One that I saw recently is one where one of these platforms was collecting information about a number of things, including how much the farmer was paying to rent a particular piece of land. And another startup company was sort of like an Airbnb for people who want to either rent land to other farmers or farmers who want to find additional land to cultivate. And it became, it sort of seemed like some of the information from the platform was being shared with the partner of the platform, which was this Airbnb entity. This is the Climate Field View is the platform, and that's owned by Bayer Monsanto. And their partner in this, the Airbnb company, is called Tillable. So you've been seeing, or I've been seeing in the social media now, Bayer and Tillable have severed their partnership because, farmers who are the ones that were renting that land were hearing that the owners of the land were getting competing offers that were almost, it almost seemed like they knew exactly what was being paid for the land. So these kinds of issues and many others are beginning to bubble up.
Well, I think more to come, because I do think this is going to be an area. There was certainly a will, Mark, when you were at the DOJ, to work very hard on these issues, and I think there is a continued bipartisan desire to do more as well. So, like I said, let's watch this space, because I think there's more to come. Mark, let's shift gears a little bit. I think listeners might like to get to know you a little bit better. So why don't you tell us something interesting about yourself that we wouldn't know if we only knew you professionally?
Well, thank you, first of all, for this whole podcast, and I've enjoyed listening to other podcasts in this series. For me, I'm in my late 60s, and one thing about me that I think my friends know is since, about age 14, I've been a huge music fan, and that's both, concerts, back in the day when you could go to concerts, and recorded music. So I decided early on that I wouldn't get stuck, listening to oldies, that I would follow anything and everything that's new. And I have done that. And so every year, I put together my best of compilations and bore my friends and relatives with playlists and CDs and things. We, gone through the whole gamut of formats for music, from records to cassettes to CDs to downloads, and now I'm back on records.
So give us a couple of tracks, Mark, that we should be listening to.
Well, the thing, the thing that I really like, I'm trying not to be stuck in the past, but I really like how my favorite era is the 1960s, and I like how the sounds from the 1960s kind of echo in today's music. So, there are bands like Deer Hunter and Fleet Foxes and Parquet Courts and a number of others that sort of feature that sound in some of their music, and that just makes me smile, and I really enjoy it.
Awesome. All right, well, let's go to our final segment that we call the Curious Hat.
And now it's time for the Curious Hat.
When we used to be all together in a studio, I used to have an actual hat that had actual questions in it, and the guest would pull a question out of the hat and answer that question. Unfortunately, since we're not all together, I have a list of questions. I'm wearing a hat. I have a list of questions from 1 to 25. And so, Mark, I will ask you to choose a number between 1 and 25, and I will read the question that corresponds with that number.
How about 18?
Question 18. What accomplishment are you most proud of?
I've had a very long career, and I'm proud of many, many things. I think the one that I'm maybe most proud of is when I was in Texas in the mid-1990s. We were the first state attorney general to issue a civil investigative demand in the Microsoft case, and I led the state investigation of Microsoft in coordination with DOJ for the many months and years prior to bringing the case in 1998. Unfortunately, my attorney general at the time decided to drop out of the case before it was brought, just months before. But that was a very exciting time, and you hear echoes of it now with all of the various platform companies and the big antitrust challenges that are in the works as we understand it.
Well, and let me ask you the flip side of that question. What's something on your bucket list that you'd like to achieve yet? Personal and professional.
I'd like to. I haven't had the opportunity to do anything in the international arena. It's so important to antitrust law, and I follow it. But I wasn't involved in it at DOJ, and the state AGs don't have a big role in international stuff. So I'd like to know more about that.
Well, you should stay close to the antitrust law section, because that is exactly what we love to do. And delighted to get you involved. Mark, thank you so much for being with us. And for those listening, we will see you next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.